Hey everyone, it's Maria Bermudez, disability lawyer, back again. Today we're going to talk about a critical part of the process when it comes to Social Security and long-term disability benefits, specifically today with respect to Social Security, and there are some similarities with long-term disability benefits as well under private policies. So when you file for disability benefits, your initial application, sometimes it gets denied. Then you file a reconsideration, and sometimes that's denied. And then you request a hearing with an administrative law judge, and then that gets denied. And then you file, when you're dealing with the Social Security process, for an appeals counsel review, and they deny you too. So then what are you left with? Many people don't realize there's another layer of appeal. You can file a complaint in federal court to have a federal court judge review the Social Security's decisions to deny you benefits. Now, at the federal court level, they're specifically going to be looking at the administrative law judge's decision. So if you've ever received an administrative law judge unfavorable decision, you know it is long. It's usually 10, 15, can even be 17, 20 pages long. And it's laying out all the facts of your case, your medical history, and why the judge feels like you are not disabled according to Social Security's rules. So once you're denied at the administrative level over and over again, at the initial application level, at the reconsideration level, at the ALJ level, at the AC level, you have 60 days to file a complaint in federal court. What does that mean? That literally means a document that is a complaint, like you would file in state court, but you file it in federal court. For Social Security cases, it has to say specific things. And what you're asking is for the federal court to review what Social Security decided. So once you file the complaint in federal court, and there's specific attorneys that do this kind of work. I do federal court work along with administrative level work. Some attorneys only do federal court work. Some attorneys do only the administrative level work, and they refer the federal court cases to other attorneys. So it's important to know the kind of attorney that you're dealing with, and they will typically tell you, I don't handle federal court cases. I'm going to refer your case to so-and-so, another firm. So when your attorney files your complaint, or if you can't find an attorney and you're doing it by yourself, that's called pro se, you file the complaint. Then Social Security has 60 days in most cases. Now, you have to check the rules. There is a national uniform rule for deadlines when it comes to Social Security cases, but most times it's going to be 60 days for them to respond with the answer, which is, it's not an answer. They're responding by filing your transcript. They're responding by filing a record of everything that happened in front of Social Security at that lower level, the administrative level. So that's what their answer is. But really what they're filing is, they're filing the record, the transcript. So your attorney or you files a complaint. 60 days later, the administration, Social Security, Office of General Counsel, will file the transcript, the certified transcript. It's Bates stamped. So it could be 1,000 pages, 2,000 pages, even more in some situations. And it includes everything, every letter that they sent you at the initial level, the reconsideration level, et cetera, all your medical records, everything that the judge had to consider when deciding your case. So the audio of the hearing is transcribed, and that gets put into the record. And at that point, once it's filed, then the attorney, the plaintiff's attorney, has to file what's called a request for review, a motion for judgment. In different jurisdictions, it's called different things, but it's all the same. It is a motion. It's like a trial on the papers. In other words, you don't necessarily have to go to court. Some jurisdictions do require oral argument, but it's not like a trial per se, where you're calling witnesses and stuff like that. The brief that the attorney writes is very long, very labor intensive. It can take several days to draft. And a lot of times it's, 20 pages, 30 pages. It depends on your specific case and how much evidence there is and what the legal argument is, but it's a very intense brief. It could be a motion for judgment. It could be a motion for request for review of the commissioner's decision to deny benefits. Some jurisdictions actually require it to be named a certain thing, but the overall goal is the same. So what you're asking for is asking for the federal court judge to find that the Social Security Administration, that the administrative law judge was wrong in denying your claim. And so in that motion, you have to lay out what they call procedural history. This is what happened. They were denied at the initial application this day. On this day, they were denied at recon. The ALJ found them to not be disabled on this basis on this day. And so you're going through the procedural history of the case. That's how we started out. And then we have to go through the facts, the evidence. So as a lawyer, we're summarizing all the medical records that are especially relevant to the federal court case, right? So as a lawyer, I may not include something like, if it's not relevant, if somebody has diabetes and the case is something like it hinges on a lumbar disc disease limitation. So I may not include a ton of history and the AC1 or A1C levels of the diabetes. I'm not going to include all that. You're including the relevant facts, the relevant evidence, and itemizing those, summarizing those for the federal court judge to have an idea what's going on. If there's opinion statements, we'll likely put it in there, especially if they're particularly relevant. So we are doing our statement of facts, and then we have to do a standard of review. In other words, we're letting the federal court judge know, okay, these are the parameters where you're allowed to review this case. You can overturn the ALJ's decision in this context under these rules, right? And it's based on precedent, what federal courts have decided in the past. And typically, in the jurisdictions that I work in, the federal court judge cannot overturn and remand a case just because they disagree. So a federal court judge could disagree with the ALJ, and they can't simply because they disagree with the ALJ say, okay, you have to go make another decision. They're not allowed to do that in the jurisdictions, in most jurisdictions, as far as I know. Instead, there has to be more like an abuse of discretion. There has to be something that's like clearly wrong in order for a federal court judge. There has to be an error of law, right? It has to be something very, very significant for them to overturn the decision. There has to be a mistake. It can't just be that the federal judge disagrees. So that's the standard of review. Then we get into the arguments. There are very specific arguments that we make when we're doing federal court cases based on other federal court cases. That's what we call precedent. Now, attorneys who do this kind of work, they know like what the federal courts, especially in specific jurisdictions, are saying. And most federal court attorneys know what federal court judges and decisions are in other jurisdictions. And so we pull on those different cases, their facts, in order to write our own brief. So say, for example, if your case is a case where there's mental health and they weren't fully considered by the administrative law judge, any limitations related to mental health, then we're going to say, hey, federal court judge, in this case that happened 3 years ago with these same facts or very similar facts, the judge remanded the case, meaning sent it back to Social Security for another hearing because the judge found X, Y, and Z, which is similar to, say, your case. So the federal court attorney that you're dealing with, would know these are the issues that we're dealing with. These are the other cases where those issues were dealt with and the outcome was favorable. So that's in a nutshell what federal lawyers do all the time, not even just specifically Social Security. Relying on precedent is like basic. That's what we learn in law school, right? We do what we call these arguments based on precedent. We also do arguments based on Social Security's own policy. Social Security has a lot of rules. They have their own regulations. They have rulings. They have a ton of their own guidance that they use to make decisions. And sometimes they don't follow their own rules. So we're going to be calling them out in the brief and being like, hey, listen, pursuant to this ruling, you were supposed to find this and you didn't. So that's what the arguments are. So there could be arguments like Social Security judge did not consider obesity. They didn't consider the fact that this person had to, their limitations were in excess of what the ALJ found. So say, for example, at step 2, which is severe impairment, say the ALJ said, okay, this person has hearing loss, but then later in the decision, when they're like articulating the limitations, they don't articulate any limitation related to hearing loss. So any sort of noise restriction, right? Like you can't be around noise, or if issues with hearing cause dizziness, then you may need a postural limitation, right? Where you can't be around vibration, you can't be required to balance as part of your job, things like that. So there's a number of different arguments that we make. If, say, the ALJ didn't consider your subjective complaints, which are credible, which are supported by the evidence. If there's opinion statements from your doctors that the ALJ did not consider, that may be an argument. So there's a number of different ways that we argue based on the facts of the specific case. No two cases are the same. So every single time we get a case from a lawyer's perspective that we're taking to federal court, one of the things that we do is we do what's called issue spotting. So we review the administrative law judge decision, and when we're deciding whether or not to take a case to federal court, we need to carefully decide whether there are sufficient legal basis and issues to actually argue in federal court. Sometimes a decision will be messed up. We will not agree with it. We're like, listen, this judge got it wrong. They should not have denied this case. But is it enough to take to federal court? That's a different issue, right? There has to be a legal basis to take a case to federal court. We don't just take a case to federal court because we don't agree with the judge's decision, because like I said earlier, there's a standard of review. So even if the federal court judge doesn't agree with the ALJ decision, they can't just overturn it, right? There has to be a legal basis. So what happens? So we file this motion for judgment in federal court, and then Social Security's Office of General Counsel has a right to respond. So they write a response brief, which is very lengthy, very involved, and they're telling us all the reasons why we're wrong and the ALJ's decision was right. And typically that's 30 days after we file our motion for judgment. They're going to file their motion in response. And then 2 weeks later, we get to file a reply. Now, while these are uniform rules as far as timing, please keep in mind, one, there could be different jurisdictions that handle it differently. And there's sometimes the plaintiff's attorney or the Office of General Counsel for Social Security will request extensions. So it may not, this isn't 100% the timelines, but the federal rules do prescribe for Social Security cases these timelines that I'm talking about. And generally that's the rule. So if a specific jurisdiction alters the rule in some way or provides a little bit more time, I have seen that. But generally, according to the federal rules of civil procedure in Social Security cases, it's 60 days to respond, 30 days to file the motion, the plaintiff's motion, 30 days to file the response from Social Security's Office of General Counsel, and then 14 days to file the reply, which is plaintiff's reply, right? So after OGC files their response to my motion, then 2 weeks later, I'm filing a reply brief saying why their response is wrong. So we're going back and forth, right? And then there's some jurisdictions where when all the briefing is done, the magistrate judge will request oral argument. Magistrate judges. Most times in the jurisdictions, at least that I practice in, New Jersey, Pennsylvania, and Puerto Rico, your case will be decided by a magistrate judge, and that's because we consent to it. So Social Security automatically consents to a magistrate judge. They're still federal judges. They're different from the district court judges. They help take things, certain aspects of the district court judges' caseload off their plate, and this is one of them. And so most of the time we do consent to the magistrate judge jurisdiction, meaning they decide the case. So with the magistrate judge will sometimes ask for oral argument. That happens in Puerto Rico sometimes, other jurisdictions as well. And so what the judge will ask for at that time is for you to explain yourself, expand on the brief. And sometimes, at least in Puerto Rico, when we do oral argument, the judge will make a decision right there on the spot at the day of the oral argument. So that's in a nutshell, the briefing and how that works. Okay. So what happens afterwards? So sometimes, like I said, if there's oral argument, they will make a decision on the spot. If not, once the case is fully briefed, you just have to sit and wait. I've had cases sitting and waiting for over a year. Most times that's not the case. Most times they get decided within, just a few months. But we really have no control over when a federal court judge is going to make a decision. So, in Eastern District of Pennsylvania, I've definitely had over a year. but that's rare. It's usually just a few months after everything is fully briefed. So we really have no control over the timing of a decision for a federal court case for Social Security. Now, what happens once we get a decision? If it is awarded, so an award, the judge isn't going to say like, okay, you're entitled to disability benefits. What they are doing is they are going to what they call remand the case, send it back to Social Security, to many times the same judge that you previously were in front of, for a new hearing. So the majority of the cases that I've had that's happened to, we do end up getting the case awarded. But I've had it where the case wasn't awarded too, when it got remanded. In other words, it's not guaranteed that the case is going to get awarded, but it's a pretty big win. And if you do get your case awarded later, all those retroactive benefits are preserved. You typically have a decent chance of getting awarded, especially if you're continuing treatment and the severity is still the same or even more severe. If the case is denied, if the federal judge agrees with the administrative law judge and is like, yeah, I don't see any abuse of discretion here. I don't see any, errors of law, whether or not they agree with the judge's decision. If they decide not to do a remand, then you do have the option to continue in the federal court process through circuit court. Cases even go to the Supreme Court sometimes, and that results in a change of law. The large majority of people who are not denied or who are not awarded or remanded at this district court level, at that first federal court, they don't go on to circuit court. So typically when you do not win your case at the district court level, that first court, that's it. You either file a new claim or, you have to discuss with your attorney what your options are. There is the option, of course, to go to circuit court, but that's not typically what I see most people doing. At that point, it's kind of, the appeals are, they're not all exhausted because you can go to circuit court, but they're exhausted for the most part, unless there is a very specific issue that your attorney feels that you need to, like a systemic issue that they want to push to change the law. That's when a lot of times we'll see a case going to circuit court, when we're seeing like things happen systemically and we need to make a point, right? Like the law needs to change in this area, or there needs to be a wider spread change and notice regarding that. Federal court is simple in some ways because it's just the briefing. And from a client perspective, all you're doing is waiting. You don't have to go to any hearings. Even if there is oral argument, you're not going to that. Your attorney's going to that. So from a client perspective, all you're doing is waiting for the decision and then waiting for your new hearing if you get a remand. From the attorney perspective, it's just a lot of writing, a lot of brief writing, that principal motion, and then the reply brief. Maria Bermudez from Disability Advocacy Group. Thank you.